The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The next case is JVC Enterprises, LLC, et al. Versus City of Concord. I want to note that Justice Berger is recused in this case. At this time, we'll hear from the appellant.
Good morning. May it please the court, my name is Keith Merritt. I'm with Hamilton Stevens Steel in Charlotte, and I'm representing the City of Concord in this case. And I would like to reserve 5 minutes of time for rebuttal. This is a statutory construction case. This court must determine what the General Assembly intended in the City of Concord's 1986 charter when it stated, all powers and duties of said board, meaning the City of Concord Board of Light and Water, shall become powers and duties of the City of Concord. The city contends that this clear, unambiguous language means exactly what it says, that all powers of the Board of Light and Water, including the power to charge for future water and sewer services, which both the trial court and the Court of Appeals agreed was a power held by the board, become powers of the city. Quite simply, all powers means each and every power held by the board. The language of the 1986 charter is clear and plain and must be enforced. This case arises from Quality Built Homes versus Town of Carthage, where this court held that cities do not have the power to charge for future water and sewer service because their statutory language does not contain the words to be furnished. In the present case, the City of Concord formerly had a Board of Light and Water that was created by local act. Again, both the trial court and the Court of Appeals found that the board, pursuant to this charter, had the power to charge for future water and sewer services as the 1977 Act, which set up the powers of the board, included the missing to be furnished language. The city's charter was revised in 1986, and as part of that revision, the board was dissolved, and the General Assembly in Section 2 stated that all powers and duties of the board shall become powers and duties of the city, and that the 1986 charter is intended to continue without interruption those provisions of prior acts that were consolidated into the 1986 charter. In matters of statutory construction, this court's primary task is to ensure that the purpose of the legislation, the legislative intent, is accomplished. The first thing that the court does is to look at the language of the statute itself. As this court recently held in Bowles versus Town of Oak Island, when the language of a statute is clear and without ambiguity, it is the duty of this court to give effect to the plain meaning of the statute, and judicial construction of legislative intent is not required. There is no ambiguity in the 1986 charter. Its language is clear and plain. Again, no question that the board had the power to charge fees for future water and sewer service. The General Assembly stated that all powers of the board, not some of the powers of the board, not just a few of the powers of the board, but that all powers of the board shall become powers of the city. The only reasonable interpretation of this language that comports with the intent of the General Assembly is that the board's power to charge for future services is a power that was held by the board, and that this power became a power to be held and exercised by the city. The language is clear, plain, unambiguous, and must be enforced as written. Just as in Bowles, judicial construction of legislative intent is not required to find in favor of the city in this case. The city simply asks that the court enforce the language of the General Assembly as it is clearly written.
In the 1986 Act, the Court of Appeals cited as an ambiguity that was critical the fact that that act both eliminated and at the same time transferred the powers of the board how would statutory construction come to play if you say there's no ambiguity there, or at least some kind of inconsistency?
Well, if there's no ambiguity, then there's no reason to engage in any statutory construction. You enforce the plain language of the statute. It's only if you find that that language is ambiguous that you then default to secondary rules of statutory construction in order to determine the meaning of the legislation. But in this case, again, the language is clear and unambiguous.
But is it possible then to eliminate a power and yet transfer the power that's been eliminated in the same statutory scheme?
I believe that it is, or it clearly is. And as stated in our brief in Lassiter versus Northampton County Board of Elections, it states the provisions of a law which has lapsed or has been repealed may be made part of a new statute by referring to the law in general terms and without incorporating such provisions at length. Reference may be made to an act which is repealed and succeeded by the act, making the reference for purpose of adopting provisions of the succeeded act. So there is nothing that prevents the incorporation of a repealed part of the 1977 Act be a part of the 1986 Charter. And what the General Assembly did made sense. In Section 2 of the 1986 Act, it first dissolved the board. Then in that section, it says the powers and duties of the board shall become powers and duties of the city. In Section 4 of the 1986 Charter, it says the intent is for those powers to continue uninterrupted. And then in Section 6, it repealed the prior provision so that you don't have two entities, the board and the city, that are both holding those powers at the same time. So what the General Assembly did makes perfect logical sense.
Is there any need here for constitutional avoidance, as the Court of Appeals has noted? And if there's no need for it, then why, as you reconcile these provisions?
We do not believe there is any reason for the court to engage in constitutional avoidance because there are simply not two reasonable interpretations of the language of the 1986 Charter. What the Court of Appeals specifically held is that we are left then with two reasonable competing interpretations of the 1986 Act. Either one, the General Assembly intended to eliminate the board's powers in Section 6 and convey any powers under the general enterprise statutes that would have remained with the board to the city under Section 2. That's the plaintiff's interpretation. Or it merely intended to eliminate the board, preserve and transfer its powers under the 1977 Charter to the city, and swept away the 1977 Charter by repeal as a matter of legislative housekeeping. Now, there are a number of reasons why that first interpretation is simply not a reasonable interpretation. The first is that it says in order to be valid interpretation, that it conveys any remaining powers under the general enterprises statute that would have remained with the board. But the board was purely a creature of local act. It had no general enterprise power that could be transferred. So in and of itself, that interpretation presupposes an impossible condition and is absurd. Second, under the plaintiff's interpretation, all powers of the board didn't become powers of the city. Again, there's no doubt that the board had the power to charge for future services. And under that first interpretation that the Court of Appeals said was reasonable, that power does not become a power of the city. Therefore, all powers did not become powers of the city. And it's not a reasonable interpretation. Third, under that interpretation, you render the rest of Section 2 and Section 4 of the 1986 Act as mere surpluses, because all you needed to do, or all the General Assembly needed in order to leave the city with only its powers under general statute, was that first line of Section 2. The board is dissolved. If you dissolve the board and don't say anything else, then the city is left with its powers under general statute. So according to rules of statutory construction, you have to give meaning to all powers and duties become powers and boards of the city, because that language isn't necessary to leave the city with just its general statute powers. And fourth, under the plaintiff's interpretation, what they're really arguing is that the 1986 charter should be read as the powers and duties of the board are changed to the powers and duties of the city under general statute. And that's in page 13 of their brief. And again, going back to the court's recent decision in Bowles, such statutory construction is not permitted because in effectuating legislative intent, it is our duty to give effect to the words actually used in a statute and not to delete words or to insert words that were not used. So that first interpretation shall become is deleted and new words are changed, are incorporated, and that's simply not allowed by the rules of statutory construction. So there are not two reasonable interpretations of the 1986 Act. That first interpretation, as set out by, espoused by the plaintiff and as set out in the opinion of the Court of Appeals, is simply not a reasonable interpretation of the 1986 Charter.
What's your response to the concern that the Constitution of our state would be violated if the position you're urging would come into play in light of the inability constitutionally to have any local laws pertaining to health or sanitation?
Well, you're asking specifically whether or not it's constitutional under Article 2, Section 24 of the North Carolina Constitution. And again, we don't believe you ever get to the constitutional questions in this case because the only way you get to them is if there are two reasonable interpretations and you apply doctrines of constitutional avoidance. Remember that the plaintiffs did not plead in this case that this act is unconstitutional. But to answer your question, the 1986 Charter is constitutional under Article 2, Section 24. You look first at the City of Asheville case. Well, before I get to that, there were two cases that were decided by the Supreme Court on the same day, the City of Asheville case and the Town of Boone case that dealt with the interplay between Article 7, Section 1 and Article 2, Section 24. So under the City of Asheville case, which was more of an Article 2, Section 24 case, the court stated in determining whether an act is constitutional under Article 2, Section 24, the question the court must answer is whether, in light of its stated purpose and practical effect, the 1986 Charter has a material but not exclusive or predominant connection to issues involving health, sanitation, or the abatement of nuisances. So the first thing you look at is the stated purpose of the 1986 Charter. And the stated purpose of the 1986 Charter is to revise the charter of the city and to consolidate certain acts concerning the property, affairs, and government of the city. So the stated purpose of the act deals with the governance of the city and all of its corporate powers. Second, the City of Asheville court was careful to make clear that the existence of a tangential or incidental connection between the challenged legislation and health and sanitation is not sufficient to trigger the prohibition worked by Article 2, Section 24 of the North Carolina Constitution. Justice Irvin authored the opinion in the City of Asheville that found that the standalone act of the General Assembly that transferred ownership of that water and sewer system from the city to a completely new and independent authority was an unconstitutional act under Article 2, Section 24. But Justice Irvin also authored a concurring opinion in the Town of Boone that found that the standalone act that removed the extraterritorial authority of the town was not unconstitutional under Article 2, Section 24. So what's the difference between the two cases where one act is constitutional, one act is not? And it is concurring opinion, and I think this is the best way to look at it.
Of course, in the interest of clarity, my concurring opinion in that case was not the decision of the court.
Certainly, but I believe
I wasn't able to persuade enough of my colleagues of the wisdom of the position that I took there.
But I think that the explanation in your concurrence is the way that you can harmonize the two cases together. And in that, in your concurring opinion, you stated, I believe that we're required to evaluate the challenge legislation as a whole and ascertain the materiality of the relationship of the challenge legislation and the prohibited subjects delineated in Article 2, Section 24 by determining whether the legislation considered in its entirety has a material relationship to one or more of the prohibited subjects. And after that, and you went through your analysis, you concluded that in light of the presumption of constitutionality, the challenge local act taken as a whole was not unconstitutional, even though some of the powers that the city would no longer be able to enforce related to health and safety. Now, it's clear in the present case that even though a portion of the 1986 charter deals with the transfer of the powers of the Board of Light and Water to the city, the charter, taken as a whole in its entirety, deals with the entire governance structure of the city and is not unconstitutional.
What do you interpret the language from the city of Asheville about the practical effect of the language of the statutory change to mean?
And that's exactly where I was going. So if you look at the 1986 charter, it deals with a host of governance issues, which the transfer of powers from the board. And if you look at the actual practical effect of those transfer of powers, it's simply a consolidation of the powers in the city. Because prior to the 1986 charter, this is what the situation was. The Board of Light and Water was created by and within the city charter for Concord and not by separate legislation. The Board of Light and Water was appointed by the city Board of Aldermen. The city manager and the mayor served as ex officio members of the board, and the mayor could vote when there was a tie. Any money that was collected by the board that it deemed unnecessary to maintain were returned to the city. And most importantly, all contracts, engagements, and enactments of the board were considered obligatory upon and were done as if done by the city of Concord. So in reality, the board operated as an instrumentality of the city, and the city was always the entity that was ultimately responsible for the actions of the board. So the only practical effect of the 1986 charter is that the powers and duties of the board are being exercised directly by the city rather than indirectly through the Board of Light and Water that it appointed. The city was and remained the entity that was ultimately responsible for water and sewer services. So there was really no practical effect. So paraphrasing your analysis in Town of Boone, in light of the presumption of constitutionality, the 1986 charter, taken as a whole, is not unconstitutional, even though some portions of the 1986 charter relate to health and safety. The other part of this, if you're going to undertake a constitutional analysis, is that the 1986 charter is also constitutional under Article 7, Section 1. And that section reads that the General Assembly shall provide for the organization and government and the fixing of boundaries of counties, cities, and towns and other governmental subdivisions. And the first clause of that section is that the General Assembly shall provide for the organization and government of cities. Our courts, again recently in the Town of Boone versus State case, have held that the General Assembly has long enjoyed plenary power to create political subdivisions of local government, establish jurisdictional boundaries, and invest them with certain powers. Based upon the Town of Boone decision, the 1986 charter is an exercise of the General Assembly's plenary power to provide for the organization and government and the fixing of boundaries under the first clause of Article 7, Section 1. And pursuant to the Town of Boone case, if that's correct, the analysis ends and there's no need to address the application of the second clause of Article 7, Section 1 and the restrictions that are imposed by Article 2, Section 24. The 1986 Act is a complete restatement of the charter of the City of Concord. It provides for the election of the mayor, the board of aldermen. It provides the powers and sets out the powers of the city manager, the city attorney, the city tax collector. It provides for boards and commissions, including the ABC board. It provides for the firefighter supplemental pension fund. And it also dissolves the Board of Light and Water and transfers the powers and duties that it exercised to the city. The dissolution of the Board of Light and Water and the transference of its powers to be exercised directly by the city is a matter that's squarely within the organization of the governance structure of the city and clearly within the plenary powers of the General Assembly under Article 7, Section 1. After considering all the evidence, Judge Crosswhite, who is actually the only one up to this point in time that's undertaken an analysis of the constitutionality of the 1986 Act, found that the 1986 Charter is concerned with the local governance and organization of Concord. The Charter provides generally for the mayor, board of aldermen, elections, and other local boards. Revising Concord's charter is within the General Assembly's plenary power within Article 2, Section 1, which is not limited by Article 2, Section 24. So the 1986 charter is clearly constitutional, both under Article 2, Section 1, as well as Article 7, Section 1, as well as Article 2, Section 24. Unless there are further questions, I would reserve my remaining time.
Thank you, counsel. We'll now hear from the appellee.
Court. I am Madeline Trilling of the Cabarrus County Bar, and I, along with my partners John Scarborough, Jim Scarborough, and Jim DeMay, also of the Cabarrus County Bar, represent the plaintiffs in these consolidated actions. I'd like to address a number of things that the city's council said, but first I kind of want to frame this issue for the court the way that we see it on the plaintiff's side. As you all know, in Quality Built Homes versus Town of Carthage, this court was tasked with interpreting the Public Enterprise Statutes 160A 314A, and the court ultimately determined that the lack of the language to be furnished determined that the Town of Carthage did not have authority to charge fees for future services. The city's act that they contend that they have authority under, the 1986 Act, does not even mention water, sewer, public enterprise services.
Ms. Trilling, just to be certain that I don't lose track of you early on here.
Yes, sir.
Do you contend that in the event that the 1977 Act had remained in place, your clients would have a claim?
In other words, that the Board of Light and Water had not been dissolved?
Yeah, if the status quo now, if the status quo in 1977 was an accurate description of where we are now.
Your Honor, we think we'd have to concede that we might not have a claim. And the reason being because in 1901, when the Board of Light and Water was initially established, the Article 2, Section 24, at that time it was Article 2, enacted as Article 2, Section 29 in 1917, was not in place yet. So there was no prohibition on the transfer at that time of the water and sewer system or anything of that nature. So if the board was still in effect.
Counsel, if I could interrupt just a second, I'm having a little bit of trouble hearing. Is anybody else, any of the other court? So I don't know if you can increase your volume. That would be great. I just want to be sure that we're all able to hear what you have to say.
No, I appreciate that, Your Honor. Thank you. Let's see this.
And counsel, I'm not going to use this against your time. If we can stop the timer until you figure out how to make yourself a little more audible, that would be great.
Thank you, Your Honor. Is that a little better?
That's much better for me. Yes, thank you.
All right. Thank you. I lost track. I think we were discussing the establishment of the Board of Light and Water in 1901. And if the 1986 Act had not been enacted, which dissolved the Board of Light and Water, presumably the board would still be in effect at this time. And as a result, there still would be authority. the Court of Appeals found that the Board of Light and Water did have authority to charge fees for services to be furnished. That essential language that this court.
So you wouldn't be here, or we wouldn't be here, except for the 1986 legislation.
I think that's correct, Your Honor.
Okay, thank you. I'm just trying to make sure I'm following you.
Certainly. Right. We contend that the Board of Light and Water was dissolved by the 1986 Act, and at that time, the city's powers to operate the water and sewer systems of the city at that time became the public enterprise authority under Chapter 160A. We do not challenge the establishment of the Board of Light and Water. We do not wish to hold the 1986 Act unconstitutional, contrary to Council's characterization of our claim. That is not what we've ever asserted. We claim that the 160A 314, the same statute that applied to Carthage, governed the city of Concord's authority to charge water and sewer fees, and that statute, and it was not the 1986 Act as the city contends. In Carthage, this court held that the lack of the essential language, the to be furnished language, rendered Carthage without authority to charge its fees. Here, as I've mentioned, the city asked you to find that it has authority to charge prospective fees when water and sewer services aren't even mentioned in the 1986 Act, much less the to be furnished language. It's long been established by this court that local acts and abrogation of a general law must be strictly construed. And municipalities are creatures of the legislature, so they can only exercise those powers that they're expressly conferred. Given that the goal of this court is to ascertain the intent of the legislature and carry out that intent, I think that it bears noting that Mr. Merritt's argument, the city's argument, is focused on one phrase, but fails to effectuate the rest of the 1986 Act. That violates a number of canons of statutory construction, which I'll discuss.
Well, let's sort of cut to the chase on that point. I think you stated, you agreed in response to one of my earlier questions that prior to the 1986 Act, the board had the authority to charge for service, quote, to be furnished, close quote. I think we agreed on that. In Section 2 of Article 5 of the 1986 legislation, as Mr. Merritt points out, it says all powers and duties of the board shall become powers and duties of the city council. If the power to charge for service to be furnished was a power of the board, why is that power not then vested in the city as the result of the enactment of Section 2 of Article 5 of the 1986 Act? I probably got the section number.
Your Honor, the answer to that question is because the 1986 Act in Section 1, which revises and specifically consolidates the charter of the City of Concord, does not include any language that relates to those powers. So there's the Section 1 doesn't contain any language.
Say that again. Doesn't relate to those powers. Just so I'm following you, what are those powers that you're referring to?
The Board of Light and Water's powers are not restated in Section 1. So there's a revision and a consolidation. The language that is used is consolidated herein into this act, the powers that are intended to continue. And the Board of Light and Water's powers, specifically the powers to charge fees for services to be furnished, was not included.
So is it your argument then that it's not proper to incorporate the language of the prior statutes in essence by reference unless they're specifically preserved? Is that the argument?
My argument, not exactly. I would argue, Your Honor, that you can incorporate by reference, certainly, except for you must have a reference. there must be a reference to a statute which, or an outside source, which can be ascertained by the reader of the statute, of the referring statute, to be able to see what law applies. The only reference, 1986.
Why is the reference to powers and duties of the board not sufficient to do that?
The repeal provision in Section 6 specifically repeals those powers and duties of the board. And so
again, I'm sorry to interrupt you, but just to make sure I'm following what you're trying to tell me. Because your argument is that because of the fact that the powers and duties were repealed in another provision of the statute, therefore there are no powers and duties which could be incorporated?
There are no powers and duties that arose from the 1977 Act. In the record, there's another statute that was that allows the board certain powers that relate to financing, that was not repealed. That power might have been transferred, for example, to the city. But
your argument is then that the only powers and duties that can be moved from the board to the city would be those that were quote unquote not repealed?
That's correct, Your Honor. I don't think you can repeal powers and duties and also transfer powers and duties. It's inconsistent, and it would be in a sort of an absurd result to interpret it that way, because at a minimum, those two provisions are ambiguous insofar as they conflict. But I think that the reading of that statute that reconciles all of the parts are that the powers of the Board of Light and Water are repealed in Section 2. They're not included in Section 1, so they're not expressly granted to the city. And Section 4 says all the powers we intend to continue are consolidated herein. And then Section 6 obviously says that those provisions are repealed. And so the only reading that really functions to give effect to all of that entire statute is the one that was adopted by the Court of Appeals, or suggested at least by the Court of Appeals, which is that the express powers were repealed, and anything that was not included in there, as I mentioned, for example, the financing, there's condemnation authority and a few other things that the board had that would have been transferred to the city. And I'll also note that Section 3 contains of the 1986 Act.
Sorry to interrupt you. So what is your contention about what Section 5 does?
Section 5, repealing the
part that says the Board of Light and Water Commissioners for the City of Concord shall be dissolved. All powers and duties of said board shall become powers and duties of the City of Concord. What does that do?
As the Court of Appeals phrased it, it's a bit of legislative housekeeping. So essentially, they repealed the express powers and duties from the 1977 Act, and then sort of put that language in there to clean up anything else that might have been omitted, or might exist under different authority, for example, contractual authority, or a different different local act. And then that became the city's obligations or responsibilities, and then the city's power to operate the public enterprise systems were those that are under general statute. And again, there's no wording in the 1986 Act about the water and sewer systems at all, and there's not even a reference to the 1977 Act outright. So if all powers and duties, even repealed powers and duties that had ever existed for the Board of Light and Water since 1901, were given to the City of Concord, that's an absurd result to come from this, and that's what this interpretation would lead to. That's being advanced by the city.
Well, let me back up a second.
I'm sorry.
Go ahead.
I just had a follow-up. So under that interpretation, what powers and duties of the board became powers and duties of the City of Concord under the 1986 Act?
the powers and duty to operate the water and sewer system that had previously been owned and operated by the Board of Light and Water, and any specific powers that were given by another local act that didn't get repealed in the 1977 Act.
And give me an example of what those are.
Yes. So as I mentioned, there is a session law in the record which specifically was related to financing, and I'll find that page number reference for you in just a moment. And it pertained to the city's ability to obtain financing and issue debt, and the Board of Light and Water's ability to do the same. That provision was not repealed because it was not contained in the 1977 Act, and so that would have continued on in force. So that would have been a power of the board that was not specifically repealed, that would have been among those powers and duties transferred by the 1986 Act. That makes sense, Your Honor?
Mr. Trilling, go ahead, Justice Hudson.
I'm done.
Ms. Trilling, you've said a number of times that there's no reference to a water and sewer system in the 1986 Act. I would agree that at least I don't see the words water and sewer there, but there are references throughout to the Board of Light and Water Commission. As I understand legislation, the purpose of the Light and Water Commissioners was to operate the water and sewer system. How is that not, in other words, a reference to the water and sewer system?
You said that there's reference throughout in the 1986 Act to the Board of Light and Water?
Yes. Mm-hmm.
I'm sorry, you're breaking up, Your Honor. How is that not a reference to the systems?
Yeah, in essence, if the legislation is referring to the board, and the board's function under the prior session laws was to operate a water and sewer system within the city, why aren't the references to the board in essence a reference to the water and sewer system?
Your Honor, the consolidation language there, I think, is very important. Again, it was 1959. This to be furnished power first appeared in the statute. It appeared again in the 60s, and in the 1977 Act, that language was consolidated in to that same provision. In the 1986 Act, that language was not consolidated in. When I say that language, I mean the specific powers and duties that were given to the Board of Light and Water. And
when you say consolidated in, do you mean, in other words, consolidated in repeated?
I mean, the dictionary definition of consolidated is to bring together and make a whole.
But
So,
in order to consolidate, as you're using that term, would it have been necessary for the General Assembly to restate in the sense of repeating the prior language?
I think so, Your Honor. I think that's correct. And I think we've seen in Quality Built Homes, this court discussed instances where powers were granted in relation to water and sewer systems. There was, mention of the recent Oak Island decision. That was a local act where specific powers were granted, and they were written and they were enacted with language, as opposed to here, where the city contends that they received this authority by virtue of a repeal of provisions, and then that were not reenacted. I think it would be that would be a violation of the legislative intent, which was intentional act, and we have to presume that in construing the statute that it was intentional by the legislature to not reenact those provisions. And so it would be at odds with general statutory construction principles, but also with the many instances in which we have seen the legislature grant similar powers and similar authority in other circumstances to find that here they could be implemented by a repeal, whereas in all these other instances they were effectuated by express grants. And as this court noted in Quality Built Homes, the first Quality Built Homes case, it's essential to our government that our General Assembly can, by express grant of authority, control the municipalities, and they're subject to the control of the General Assembly. In looking at this issue from a broader perspective as a policy consideration, if the General Assembly could enact by virtue of a repeal, or could grant powers by virtue of a repeal, or if this court were to interpret this repeal as granting this authority, this massive authority, which is greatly in excess of the general public enterprise authority, the courts would be flooded with cases where people were arguing about what authority they actually had. It is very common for statutes to be repealed, as you all know. I mean, it happens all the time. In every instance of a repeal of any provision, there would be a possibility for a disagreement or debate about, what authority was actually repealed and what continues on in existence. The cases that Mr. Merritt cited or City's Council cited in their brief, the Lasser case he specifically referenced, those cases all involved instances where there was a specific reference to the statute that was meant to be incorporated. We do not contend that the General Assembly could not have incorporated by reference the 77 Act, but we do contend that it did not in the 1986 Act. The powers and duties of the Board of Light and Water is simply not specific enough. And again, this court cited the Lutz case in the 2017 case of Fidelity Bank versus North Carolina Department of Revenue, and said, when the General Assembly intends to adopt provisions or definitions from other sources of law into a statute, it does so by clear and specific reference. And I would contend, Your Honor, that that's important again, from a practical perspective, for a citizen to be able to look at a statute and be able to determine what that statute intends to incorporate in as its requirements or its obligations for that individual. So here, I don't think you can do that, and I think that's problematic. I also contend that, again, to go back to briefly to the consolidated herein, it would be inconsistent for the powers and duties to be consolidated herein and also incorporated by reference. Those two things are mutually exclusive, and I think, again, would contravene the plain language of Section 4 to adopt that interpretation. Does the court have any questions before I move on to the constitutional avoidance issue? Any further questions about? Okay. At a minimum, as we said, there's a conflict in the language of the 1986 Act, which again we contend is clear and unambiguous. But in the alternative, if there is an ambiguity, then principles of statutory construction come into play to include the doctrine of constitutional avoidance, and the Court of Appeals opinion, as you all know, ultimately held that doctrine required the court to adopt the interpretation that is advanced by the plaintiffs, which is that the city's powers to operate its water and sewer systems were limited to those that it possesses under the general public enterprise authority. And this Court of Appeals analysis, I think, was well done, and it's on point with regard to the constitutional avoidance issue. And again, I think the court asked the city's council about, what do you think about constitutional avoidance? And the city and Mr. Merritt responded that it doesn't come into play unless there's ambiguity, which is true, and we would certainly agree with that. But I think that if, again, looking at the 1986 Act, there's certainly some inconsistent provisions in there. Again,
Ms. Trilling, just to be clear, in the event that we found the statute to be clear and unambiguous, either as Mr. Merritt has alleged that it should be construed, or as you have alleged it should be construed, we would not need to worry with constitutional avoidance.
I think that's correct based on the precedent of this state, Your Honor. Although this court has an obligation certainly to try to construe things to be constitutional in order to effectuate the legislative intent, which we presume is intended for.
Well, let me again, just to make sure I understand what the nature of the inquiry that we ought to be conducting is. My understanding, Mr. Merritt, in one of his briefs, argued that in the event that the language was clear and unambiguous, that it had to be construed in accordance with its literal language. regardless of whether the doctrine of constitutional avoidance would suggest another option. Is that also your interpretation of our decisions?
I think that's correct, Your Honor. I think that specific doctrine would not come into play unless the court found that there was, and that there were two reasonable interpretations of the 1986 Act. That's also a necessary element. But what the constitutional avoidance doctrine is not, and I want to address this because the city's brought this up a number of times, is an effort to have the 1986 Act declared unconstitutional. We do not seek to have that declared unconstitutional. We just don't think it applies in this case, and we think that that the court should adopt our interpretation, which is consistent with that determination. It's basically a means of deciding between two different interpretations. Although I will note that we have disagreement with the city a little bit about the proper standard for the application of that doctrine. The city argues that it has to be plainly and clearly unconstitutional for that provision for the constitutional avoidance doctrine to apply. And based on this court's precedent, the language that we understand to be applicable is that there has to be a serious doubt as to the constitutionality, and in order to invoke the constitutional avoidance doctrine. The city contended that, and so to state the doctrine, it essentially is where there's two reasonable competing interpretations of a legislative act, and one of those interpretations potentially raises serious constitutional questions. It's the duty of the court to adopt the other interpretation so as to avoid those constitutional issues. And here, as Mr. Merritt was arguing, we contend that that under the city's interpretation of the 1986 Act, that act would be unconstitutional under Article 2, Section 24, and particularly based on this court's decision in City of Asheville. And I'll note that there's an argument that Article 7, Section 1, Clause 1 applies, which, as you all know, allows the General Assembly to provide for the organization and government. But there was an agreement that came out of City of Asheville and Town of Boone amongst all the opinions, I think, except for Justice Beasley's. It was agreed that where specific powers and duties are assigned, this court's obligated to undergo the inquiry under Article 2, Section 24. Article 7, Section 1, Clause 1 is not the end of the analysis. So I think that this court, under those decisions, is obligated to at least undertake the Article 2, Section 24 inquiry. The transfer of powers and duties, which is exactly what the city contends happened here by its plain language, has to be reviewed under Article 2, Section 24 in this instance. It cannot be an exercise of the plenary authority. So, and just to note briefly, as the Constitution permits, obviously, the General Assembly to repeal any local act that's been enacted previously, in order to, which in this case, we would have the effect of transferring the systems to the city, or transferring operation of the systems previously belonged to the Board of Light and Water. That would be the effect of it, but that's lawful because the Constitution permits the repeal of a local act, and that's also in Article 2, Section 24. In the Asheville case, this court held, the majority opinion held that where a local act transferred ownership, operation, and governance and enforcement authority over the city of Asheville's water and sewer systems to a separate entity, that was violative of Article 2, Section 24. And as the court notes in that opinion, that's consistent with a long line of cases that have held that a transfer of such authority is problematic and violative of Article 2, Section 24. This is not merely an instance where there's a change in extraterritorial jurisdiction, such as in the Town of Boone case, or or plenary authority, regulatory authority, or something of that nature, reorganization of government. This is a case where the city's interpretation is that powers and duties specifically were transferred, and significant powers and duties. And I want to also note that we're talking about go ahead, Your Honor.
I was just going to ask you, does it make any difference in this case that what the transfer, assuming that there was one, was between an entity that was essentially, at least as I understand it, a body of folks controlled by the city's council to the city itself? Does that make any difference?
Your Honor, I think that it's just not the case that the Board of Light and Water was the same as the city, and we argued with that extensively in our brief. They were two separate municipal entities. It was a separate.
Just to cut to the chase in the interest of time, they're clearly two separate legal entities. My understanding from the record is that the board itself was essentially, with the exception of one ex officio member, the mayor, was appointed by the city council. Is that wrong?
No, that's correct, but I don't think that renders them a governed by the city. I think it's still certainly a separate entity, and the transfer of that authority is no different than it would be for the transfer between New Bern and a county or any other instance of separate jurisdictional entities. I don't think that, and again, we discussed this a great deal in the brief, but those are separate municipal corporations, and we have to respect and acknowledge those distinct forms, again, having been enacted by the General Assembly in 1901 to begin with. I think that's a critical thing to note. And I also just briefly want to note that that the city said that claims that the 1986 Act was a complete reorganization of government, and they argued this before the Court of Appeals, and the Court of Appeals, I think, correctly held that that in fact the 1986 Act, the practical effect, as the City of Asheville Court noted, was critical, if not determinative, of the inquiry, is that this repeal of the Board of Light and Water was the primary goal of that act. If you compare the 1977 Act side by side with the 1986 Act, there are virtually no changes other than to repeal the Board of Light and Water and to effectuate that repeal.
Council, I'm afraid your time has expired.
Thank you. Thank you.
Thank you very much.
Thank you.
Rebuttal.
I'd like to start first with the argument that council made that if the powers and duties are repealed, they can't be transferred. Well, think about that for a minute. If the powers and duties were repealed and could not be transferred, then there's no need for the General Assembly to say that all powers and duties of the board became powers and duties of the city, as the board had no other powers other than those that were granted to it by the legislature. So the interpretation that you just heard from council renders all powers and duties of the board becoming powers and duties of the city as surplusage and as a nullity. So it's an illogical interpretation, because if the intent was to just leave the city with its powers under general statute, nothing more had to be said than the board is dissolved. And if you want to add in that its powers are repealed, that's fine. But you have to give meaning to what the General Assembly said when it said all powers and duties of the board became powers and duties of the city. And as counsel for the plaintiffs admits, the board had the power to charge fees for future water and sewer services. So that was a power of the board. It's one of all the powers of the board, and it is one that was transferred to the city. The General Assembly meant what it said. All powers and duties of the board, including the power to charge for future services, became a power of the city. A point came up with respect to whether or not this is a transfer like in almost or every other case that I think you can point to where there was a transfer of powers between two entities. The two entities that were involved were completely separate, distinct entities. You are talking about a city council as opposed to a county board of commissioners. You were talking about a health authority as opposed to a county. You were talking about completely different entities. And in this case, the city was always legally obligated, contractually obligated for every act that was undertaken by the board. All contracts and obligations of the board were obligations of the city. So it's not like you are dealing with the situation where you're moving from one distinct entity to another distinct entity. Yes, they may have legally corporate distinct entities, but in reality, the board operated as an instrumentality of the city always, and the city was always on the hook for what the board did. So it is not the same situation where you are transferring it between two separate entities. It is, as was stated in the Town of Boone case, it's a rearranging of responsibility under Article 7, Section 1, and is purely constitutional if you're looking at it from that perspective. There's no question that the City of Concord Board of Light and Water had the power to charge for future water and sewer services. There's no question, and has been admitted by council, that the 1986 charter explicitly states that all powers and duties of the Board of Light and Water shall become powers and duties of the City of Concord. And let's not lose sight of Section 4 of that act as well, which says that all powers and duties consolidated herein are intended to continue without interruption. There's also the only interpretation under which the power of the board to charge future water and charge fees for future water sewer services is the one that is espoused by the city. The language of the 1986 charter is plain, it's clear, and following the rules this court has set out in Quality Built Homes v. Carthage and Bowles v. Town of Oak Island, the language should be enforced as written. There is no need for this court to apply secondary rules of statutory construction given the plain language. As we stated earlier, there are also simply not two reasonable interpretations of the 1986 charter. The plaintiff's interpretation fails because it relies on the presumption that the board had powers under general statute that were transferred to the city. No such powers exist, and such an interpretation is absurd on its face. The plaintiff's interpretation also fails because under it, all powers of the board do not become powers of the city. To affect the intent of the General Assembly, all means all. The Court of Appeals found that the board had the power to charge for future water services, but the court then adopted an interpretation where that power and duty did not become a power and duty of the city. Any interpretation of the 1986 charter where a power that was held by the board did not become a power of the city is contrary to the plain, clear intent of the legislature and must be rejected. The plaintiff's interpretation again also fails because it renders parts of the 1986 charter as surplusage. Under their interpretation, there is no need for the General Assembly to include the language, all powers and duties of such board shall become powers and duties of the city. And because there are not two reasonable interpretations, there's no basis for this court to invoke the doctrine of constitutional avoidance. Finally, as we went through before, even if the court considers the constitutionality of the 1986 charter, it is clearly constitutional under both Article 7, Section 1 and Article 2, Section 24, as has already been determined by the trial court, which so far is the only court that has actually undertaken an analysis of the constitutionality of the 1986 charter. I think the question before this court is very simple. Did the General Assembly intend by the 1986 charter to strip the city of the power to charge for future water and sewer services, a power that the board had held since 1959? Or did the General Assembly intend that the city continue to have that power without interruption? The plain, clear, unambiguous language of the General Assembly states that all powers and duties of the board shall become powers and duties of the city. And that necessarily has to include the power to charge for future water and sewer services. And that power shall be held by the city without interruption. We would ask that the court reverse the decision of the Court of Appeals and find in favor of the city. If there are any further questions, I'll be glad to answer them, but otherwise I'm concluded.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Thank you very much for your time and attention to this matter. I truly appreciate it.